Good afternoon. Welcome to the HIVE, the NTFP e-learning platform. Why HIVE? This is inspired by the beehive, place where bees exchange information. Bees exhibit this dynamic interaction in the ways that they strategize and socialize as they look for food from floral sources and when they carry it back to the command center. It is in the hive where their most essential knowledge sharing system takes place. This hive platform will strive to have that dynamic interaction and information exchange. Looking at the screen and around me, we are about 20 excited bees to be excited to be part of this hive interaction. Before we begin the webinar, let us first set some rules. We kindly request all participants to mute their microphones all throughout the session. Hopefully, don't take any phone calls. If you have questions, please click the raise your hand button, and then we will address your questions, whether orally or send you a text reply. You can also maximize the chat box. And the presentation will last for 1 hour to 2 hours and are divided into subtopics. And we will have a short Q&A for around 5 minutes after each subtopics. And then where you can also ask questions, we will answer some questions and we can also seek some clarification. Now, are we ready? Well, hope we are ready. So NTFP, as you all know, works towards making self-empowered generations of forest-dependent communities who benefits from sustainably managing their forest and its traditional knowledge and cultural traditions. For centuries, indigenous peoples and local communities around the world have learned, used, and passed on traditional knowledge for many purposes. Now, from food, medicine, clothing, up to practices such as good planting, good harvesting of NTFP, good forest management practices, these are all embedded with traditional knowledge. So working towards self-empowered indigenous peoples and local community is also to ensure that these communities are aware of existing tools of protection of community intellectual property rights. We will know what is intellectual property rights, especially, of course, when they're building community enterprises. The 3 webinars are designed in such a way that we will first have an introduction to United Nations WIPO system and its principle. That's the mainstream approach, and looking at which tools are useful for us who works with indigenous peoples on the ground and at the national, regional, and global level for policy engagement. And then we will focus now on the traditional knowledge and traditional cultural expression and practical ways, both legal and non-legal, which can be useful for communities. For our first webinar, we are pleased that we have an expert in the house. Attorney Jean Corpus is a lawyer from the Kankana Igorot tribe of Mountain Province in the Philippines. She is from Tebteba and was a fellow as an Indigenous Intellectual Property Fellow at the UN WIPO in 2012, and since then has been an active participant in the WIPO Intergovernmental Committee on the protection of traditional knowledge and sometimes chairing it, aside from being an active participant. So she is also involved as a negotiator for the International Indigenous Forum on Biodiversity, representing indigenous people for the negotiation leading to the Nagoya Protocol under the United Nations CBD. So let's welcome Attorney Jean Corpus.
Thank you very much, Edna. There you go. Now you can see me. Thank you very much, Edna, and thank you for the kind introduction. So welcome everyone and good afternoon. This is, as Edna said, this is the first in our series of webinars. And maybe let's just launch straight into the presentation. Okay, there we go. So for this session, our objectives are three. First, we want to be familiar with the international system, or that is the current international system for the protection of intellectual property. As well as, we also want to take a look at the tools that are available. During this session, we will focus more specifically on the tools, the mainstream tools. We will have glimpses as to how they relate to traditional knowledge and traditional cultural expressions. We won't go very deeply into the nexus between those, because that is the topic for our second webinar in our series. One of our other objectives is to identify the limitations of the system as well as the opportunities provided for the protection of traditional knowledge and, of course, traditional cultural expressions. We also want to know a little bit about the Madrid system for the international registration of marks, since this seems to be the most useful for indigenous peoples. Okay, so for this presentation, the outline is as follows. There are 4 parts to the presentation. First, we look at the basic principles of the intellectual property system. Then we make a survey of sorts. We look at the basics of the 7 different intellectual property tools that are most relevant for traditional knowledge. And then we go, as I said, not very deeply, we have a glimpse into how the intellectual property system relates to TK and TCEs, and finally the Madrid system. Okay, so let's go straight into the substance of the discussion. We're all familiar with property. We have, for example, we have land, maybe we have cars, maybe we have cell phones, we have computers, and creations of the mind are also a type of property. The only difference is that you cannot touch and hold these types of property. That's why they are called intangible types of property. So, in short, creations of the human mind are also property, and as such, there are also laws that protect these types of intangible properties. Okay? So, as I said, it's a legal property because there are laws. But so therefore, their nature is that they are exclusive and private rights. What does that mean? It means that the creator owns the intellectual creation, and his ownership is in the nature of private rights, which means that they can prevent others from using their creation without their express consent. Sometimes, for some of the intellectual property tools, there is a requirement to register. And you will see later, I will present the examples that you sent to me, which are registrations of trademarks. Okay? The limits provided, however, by the intellectual property system and the tools within the system are that they are time limited. Okay? There's a limit as to time. There is a limit as to geography. In other words, if you register it in the Philippines, it will only be protected in the Philippines. And after the expiration of this time limit, then the creation or the knowledge goes into the public domain. Okay, are you with me so far? Okay, so let's move on. Here is merely a graphical presentation of what I explained earlier. So intellectual property rights is a balancing act. Okay, so it balances the rights of the creators to what they have created and the right of the public to use that creation. Okay, so we see there is a symbiotic relationship shown by those arrows. So we protect the moral as well as the economic rights of the creators, but also allow the public to access the fruits of the creativity. So, how has the intellectual property system evolved? And this is from the WIPO website and several of its publications. The intellectual property system was born during the time well, they say the age of enlightenment or the era of industrialization. So if you've heard of Albert Einstein and who else are the very famous creators? Maybe Alexander Graham Bell, who first created the telephone. That was the time when they were actively creating or inventing certain products. So at the time, there was an international inventors fair that was being organized. And suddenly, towards the 1870s, they noticed that inventors were very reluctant to come to these conventions because they were scared that their inventions might be stolen. And so that gave birth to the Paris Convention, or rather to a convention in 1883. You can see there in the timeline. I will encircle it for you here. So you can see in the timeline that there was a convention where inventors discussed a system by which to protect their creations, their inventions. A few years later, there was another convention, and this was for artists, and basically to protect creativity, creative works. Okay, and of course, whenever we have conventions, there has to be a body that that oversees implementation of the convention. So there were two bureaus created, and that's why we have in 1893 what we call the BIRPI, BIRPI. That is a French name, so I will not attempt to pronounce it, but it's essentially the United Bureaus of the Paris and the Bern Convention. Okay, so and the whole point of my showing you this timeline is actually to show that as the times progressed and evolved, the different intellectual property tools that were agreed, negotiated, and agreed evolved with the changing times. So, for example, during the time of the Bern Convention, marks were protected, trademarks. So, a trademark would usually be two-dimensional drawing, okay? Maybe black and white at the time. No, I'm just kidding. Maybe already colored. But now, as technology progresses, you can see in 2009 in the timeline, there is now a Singapore treaty that would recognize the different ways by which a trademark might be expressed. So it includes smell, holograms, taste even, and also, computer-generated graphics. Okay, and of course, in the later part of the timeline, we have the two latest treaties. One is about audiovisual performances. So copyright law only protects those that that are fixed. But of course, the performers said that what about our performances? How come they cannot be protected? So treaty was negotiated and adopted in Marrakech. And later in Beijing, there was another treaty to address the needs of blind people. Okay, so it evolves. I purposely left the timeline towards the end blank because there is one treaty that is currently being negotiated. And this is about the protection of traditional knowledge and traditional cultural expressions. Okay, so there is something wrong with my screen. Okay. I have a problem with my screen, but I think it's because of the graphics. I cannot remove the graphics. Okay. So one other interesting aspect of this timeline, if you can see, WIPO was only established in 1970 exactly. This is the World Intellectual Property Organization, and it was the successor of this BIRPI. Okay, And it is one of the specialized agencies of the United Nations. And their area of specialization, of course, is intellectual property. And they are the only self-funding UN agency. In short, they generate by themselves, generate all of the funds that they need to operate. Not like the other UN agencies that require countries to contribute in order for them to be able to operate. Okay. The problem is that I don't have a pointer. So there are around 191 parties to the WIPO Convention, which means that there are 191 members. So that's almost the entire universe of countries worldwide. Okay. There are 1,000 employees all over there. Okay. I would like to thank the tech people here who are beside me supporting this. Okay. So let's continue. Okay. Very good. So, as I said, the mandate of this specialized agency is the protection of intellectual property rights. Okay. The decisions are made by the General Assembly, which convenes once every year, and assemblies of each of the treaties. Okay. What does it do? Basically, there are 4 areas. Policy, where they negotiate treaties. They have services, which are the services that they extend for filing, protection for patents, trademarks, designs, and geographical indications. They also provide technical infrastructure so that all countries, specifically the intellectual property offices of each country, can share their information. Then finally, in 2007, there was a clamor for WIPO because it's a rich agency. It funds itself. There was a clamor for it to have a development agenda because, as we said, time is changing, and there are some countries who have been very active in the intellectual property field who were able to generate a lot of resources, while some other countries were sort of left behind, the developing countries. And so they have a development agenda, and this is what they do under their mandate on cooperation. Okay. There are several external offices of WIPO. There's one in Brazil. They're very fortunate for Asia. There are 2 in Japan and in China. Well, Russia can actually be considered part of the Asian region because it's very close. Oh, and also Singapore. So almost all of the field offices, the external offices, are here in the region. Okay. Why do I emphasize this? Because when we look at the tools later, there are mechanisms within WIPO that would enable protection of your intellectual property in many different countries. And the external offices would be instrumental. Of course, everything would start with the national level. And here I tried to look for all of the logos of the countries represented here, but I don't think I managed to do it. So we have the Intellectual Property Office. I think that is the third or fourth different logo. We change logos very frequently here in the Philippines. Of course, Indonesia also has an Intellectual Property Office. Myanmar, the Intellectual Property Office is located within the Ministry of Commerce. Okay, so sometimes it's not an intellectual property office as such. It might be an office within a different ministry. For example, in Indonesia, Ministry of Law and Human Rights. Okay, so this is important because later you would have to find where to file. Because when we access the international system, things would have to go through the national system first. Okay, so for example, and apart from knowing what office is in charge of protecting intellectual property within your country, it's also important to look at the legal landscape. For example, in the Philippines, and here I'm reproducing a table that was developed by one of the intellectual property experts here in the Philippines. And he enumerated many, many different laws that would deal with intellectual property and traditional knowledge. Okay, so obviously we have the intellectual property code. So later, when you've learned the basics and you try to apply what you have learned, you would have to look for the office and you would have to look for the different laws. Okay. There we go. Okay, now for the intellectual property tools. Okay. So I have been advised that this is time for a poll. We're trying to see if you are listening carefully to what we are. Of course, there's some consideration, special consideration for those who have very poor sound quality. Okay. Okay. So among the intellectual property tools, which ones are you familiar with? And please place your answers in the poll. I've mentioned a couple earlier during the first part of the presentation. So, okay, so we wait for 30 seconds. Okay, so let us continue. Okay. So, I guess you are, wow, this is surprising. Copyright, it's not surprising that many people are familiar with copyright. Patents, a fair number. Trademarks, of course, because you work with it. But I was surprised about geographical indications. Okay. So Attorney Edna here is telling me that NTFP staff are familiar with geographical indications. Okay, so let's move on. Broadly speaking, there are two different types of intellectual property tools. One would, on the left side, you would see in the industrial property, and that would, under industrial property, that would be patents, trademarks, industrial designs, and geographical indications. These are the stuff that you're very familiar with, okay? Then, to the right, you have copyright and related rights, okay? Literary, creative works, artistic works, musical works, so songs, plays, dances, etc. Okay, what is the difference? Why do we classify it this way? Copyright, in general, and related rights does not require any type of registration. The mere fact that you created it means that it's yours and that you hold the copyright to the work. Whereas industrial property has plenty of formalities, okay? So we will see that later as we go through our presentation. Okay, so this is the listing that you saw in the poll. And so we move on and take a look at the tools. So what is this a picture of? Of course, I can't hear your answers, but if any of you answered Romeo and Juliet, that's the correct answer. And the reason why I put it here, is because it's to illustrate one of the basic principles under copyright, which is that you protect the expression of an idea, but you do not protect the underlying idea. And for example, Romeo and Juliet, there was the original. However, it has been reinvented many times in movies, in romance pocketbooks, in many different plays. And that is because when we talk about copyright, what is protected is the way that the idea is expressed and not the idea itself. Of course, the work must be original, which means that you did not copy it from from anyone, but you're allowed to be inspired by something. So you can be inspired by Romeo and Juliet and, create a love story similar, but not exactly the same. Okay? You can also borrow a little bit, but you cannot copy exactly. Okay? So as I said earlier, you don't need to register. Okay? So what are the examples? Examples, of course, dances. You have ballet, songs. You have here architectural designs also included. We have plays. And you see here that picture with the lizards. That is actually a creation of Aboriginal artists. So it's possible for indigenous peoples to create create something and for it to be protected by copyright. Okay. Now we move on to the next tool. I hope copyright was clear. Okay. And as I said, later we can, at the next webinar, we can explore. No. Actually, this is the time to do it. Okay. So for copyright, how have indigenous peoples used this? One example from Australia would be the use of Aboriginal art to produce other types of products. So an example is that lizard design that you see there. Something similar was used by someone else, a member of the tribe, but she used it for herself, not an artist, and she manufactured carpets. It was manufactured in another country, not within Australia. And so the actual artists complained about it, no? And it was proven that the actual owner are the artists and not the businesswoman who had carpets produced using the Aboriginal design. Okay, so it can be used. Okay, the next tool that we discuss now, and you're very familiar with this, as shown in the poll, is patents. And what are patents? These are it's basically a tool to protect inventions. So what are inventions? It's something that is useful, no? It has an industrial application. That means it's useful. It's a new solution, to a problem faced by humanity. Of course, in order for it to be protected, it has to be new, and there has to be an invention, precisely because of the name. It's an invention, no? Okay, so it can be a technical solution to a problem, or it can be a new way of doing things. So what is an example of a patent? We have here an ice cube tray. So you ask, what year was this created? This is something that is very common, no? But actually, there is an innovation here. Because normally, when we have our ice cubes, no, if we put it in an open tray, if it's just open, no, sometimes it's very difficult to remove just a few. Yeah. In order to remove a few, sometimes you have to twist the ice cube tray, and everything falls out. Now here, the innovation, and also sometimes when we put our ice in the refrigerator and it has fish, for example, beside it, what happens to our ice? It begins to smell like fish or other types of meat. Okay, so this new innovation, it created a cover for the ice cube tray. No, it can be something as simple as this, actually. There is a cover for the ice cube tray so that it is possible to remove a few ice cubes at a time. if you don't need the entire tray. Okay? So you can see that there is a innovative, a new creative solution to a problem. No? Okay. And of course, it won't smell like fish because it is covered. Okay? So, how has this been used by indigenous peoples? There are two ways that the patent system has been used for traditional knowledge. Okay? One is to prevent others from applying for patents on knowledge that indigenous peoples know and have been using since time immemorial. Okay? A good example here would be, for example, maybe from, most of my examples are from Africa. I would apologize. But one example from Africa is this rooibos. You might be familiar with it. For those who love tea, it is one type of tea called the rooibos. It's from South Africa. Yeah, and it is from a bush in South Africa. Okay. Now, this has been used by the Khoi and San tribesmen, well, maybe tribeswomen as well, probably tribeswomen. But the tribe has been using it for a long time as an anti-inflammatory, okay? It prevents swelling, okay? So, a company wanted to patent it, the rooibos, and said that it can be used to prevent inflammation. And so the tribe was able to say, that we have been using this for many, many years, since our forefathers, our grandfathers, and their grandfathers. So the patent was not granted because it wasn't new and there was no inventive step that was applied in order to make it into a new invention. Okay? The other way that patents have been used by tribes is by partnering with certain academic institutions in order to further develop their medicinal plants. Okay, and again, examples here are mostly from developed countries such as Australia, where a tribe has partnered with universities in order to develop and patent one of their medicinal plants. Okay, so that's patents. Now we move on to trademarks. So trademarks, you can see here in this screen, many, many familiar logos, because trademarks are basically logos. And it is used to distinguish your corporation, well, your group or your corporation or your company or your association. And it is used to build a reputation around the quality of the product that you are producing. Okay, so once you've built that reputation, the brand will become very valuable, because when people look at the brand, they would know that there is good quality, no? Based on the brand and the reputation that you have built. Okay, so this has been used, as you can see. I put in here some of the trademarks that the NTFP has obtained, has registered. Okay, and here in the upper left-hand corner is an example of a collective trademark. And this collective trademark, it's very useful because many indigenous peoples own some of their creations collectively. Okay, so in Lake Cebu, among the Tiboli tribe, they weave these patterns called tinalak. No two patterns are the same because they are generated. The patterns are generated from dreams. That's why they are called dream weavers. Okay. Now, all of the weavers within the community came together and decided to apply for a collective trademark. But before they put forth their application, they first developed their code of practice. And basically, it's just codifying the way they traditionally make the cloth, no? And the rules surrounding the use of the woven cloth. Okay? So, and this code of practice is meant to assure that the quality of the product is consistent and excellent. Yeah? So, That is their trademark, collective trademark. The one here on the upper right-hand corner is a similar trademark, but in relation to agricultural products. The indigenous peoples in Peru, which is the center of origin of potatoes, are of course known for their potatoes. No, they have it's a unbelievable variety, number of varieties of their potatoes in Peru. And they applied for this certification mark called Sumak Songko. And this certification mark is meant to assure people that the quality of the potatoes with this mark are very good, and they are from the potato, from the indigenous farmers in the Andes. Okay. Many examples, but we will go through them very deeply at the next installment of this webinar. Okay, so those are what the certificates of registration look like. And yeah, so these are the principles surrounding trademarks. They are basically signs that protect brands and reputations. Therefore, they are very important for marketing. They may be words, letters, numbers, or symbols. They may be a shape, no, like the check mark of Nike. Okay, they may have sounds and fragrances. Okay, as I said, the Singapore Treaty now also recognizes holograms. So, what does it need to what does it need to have in order to be protected? It must be distinctive. So it must not be very confusingly similar to other marks. It cannot be generic. So, for example, you want to trademark water, and then you want the trademark to be water. No, it cannot be. That's not allowed because it's generic. Okay? And of course, it has to be registered. Okay? And the reason why this type of tool, this type of protection is interesting for indigenous peoples is because it is renewable indefinitely. There is no expiration. For patents, the time limit is 20 years. After 20 years, it goes into the public domain, which means that anyone can use it without permission. Okay? So trademarks, you can, the period is 10 years, but as long as you renew it and you pay the fees, it can be renewable forever. Okay? So again, those are the examples. Then, so that's for trademarks. Then we move on to geographical indications. And maybe most of you are familiar, so I won't be very specific with this. But basically, this has to do, it's a sign on products that are distinctive because of where they are from. So it's a specific, unique because of the geographical features of the place where it is from, or because there's a reputation surrounding where it comes from. Okay, can be natural factors, like the soil, because sometimes the type of soil influences the taste of certain agricultural products, or the climate. Okay, there are also human factors such as skills, and of course we have champagne as one of the best examples of geographical indications. Here in the Philippines, we tried to register as a GI Guimaras mango. The only problem is in the Philippines, we do not have a law on geographical indications. In fact, the tinalak of the Tiboli in Lake Cebu, they also wanted geographical indications for that. But because we don't have a law, they just registered it as a collective trademark. Okay? Because, So, examples here are this tea, which is from, that name I cannot pronounce. Parmesan cheese. Yeah. Coffee from Colombia. Apparently, it has a very distinctive flavor because of the soil in that area, etc. Okay. Of course, champagne and Roquefort. In Europe, there are many different kinds of cheeses. And apparently, the name reflects where they are from because the unique geographical conditions in those places give the distinctive flavor to the cheese. Okay? So that's for geographical indications. Now we have industrial designs. Industrial designs protects the how a thing looks or feels instead of how it is used, no? So it's the aesthetic rather than the function of a thing. Okay, of course it must be new. It mustn't be design that has been copied from somewhere else, and it usually must be registered. And a sad example here is do you know in Australia there is this musical instrument? It's like a flute, but it's very, very long. And it is used by Aboriginal people there in Australia. It's called a didgeridoo. I don't know the proper pronunciation, but that's how it's spelled. And so someone tried to register something that looked like that. When the Aboriginal people said that it cannot be registered because it is not new, we already have it, they weren't, the protest wasn't successful because they did not register, okay? This is one limitation of the intellectual property system. In order to know who invented something first, it's important that there is a date. A date when the protection started. So this is one, this is one motivation for indigenous peoples to register some of their designs, because if they don't register, then they cannot claim that their design came before someone new who is just copying their designs. Okay? So here are examples. And it can actually be used for weaving patterns. You can see there the tinalak cloth in the lower right-hand corner. And on the lower left hand, that is a traditional weaving from my people, the Igorot. Okay. Then you have that funky-looking chair. Okay. Those are the types that get registered for industrial designs. The only problem here is that there is a time limit to the protection. After that time limit, then anyone can use without permission. Okay, so how many tools did we already discuss? We've already had copyright, patents, trademarks, geographical indications, industrial designs, and now we go to the last two. So the last two are basically tools that do not protect as such, but are supplementary to the other tools. Okay. So one is unfair competition. So this is, it protects, certain creations against unfair practices, basically. Okay, so what are the examples of unfair practices? One is the false labeling of products. For example, when somebody says that this product that was created by an Aboriginal community or by indigenous community, this payment is going to the indigenous community that created this product. That can be one false labeling when in fact there is no payment that is going to the community. Okay, creating confusion. These are the confusingly similar brands, and passing off your product as if it was something original and yours. Okay, those are the things that the law on unfair competition wants to prevent. Sorry. Okay, and finally we go to the last tool. You might be getting tired now, maybe full of information, but now we have the last tool, and this is also relevant for traditional knowledge, because as indigenous peoples would say, a lot of traditional knowledge that they want to protect are the sacred and secret traditional knowledge. So this concept of trade secrets might be useful to protect secret and sacred traditional knowledge. So it's also known as confidential information, and it protects secret knowledge. No? It wants to prevent others from using the information that is secret. However, it will not protect where there has been incidental or independent discoveries. Okay? So what are the examples? Very famous. Coke and KFC. I don't know what KFC is called in your countries, but KFC and Coke have very unique recipes for producing the taste that they are very famous for. And these are really very, very closely guarded secrets. Okay? Now, what is the application for indigenous peoples? In one area where a tribe shared with a researcher some confidential information, the tribe, because they found out that the person that they shared information with was about to publish a book with the information, the secret information that they had shared to him in confidence, the tribe then, tried to work to prevent publication of the book on the basis of secrets. Okay, and they did. They were successful. They prevented publication because the person who was publishing the book, who wanted to publish the book, was not authorized to share the secret. Okay, so we come to the end of that's the summary of the tools, the basics of intellectual property and the tools. Okay, so again, the tools are patents. Okay, indigenous peoples can use for their medicinal plants. Copyrights, which can be used for certain creations of indigenous artists. Then we have trademarks, which is desirable because it does not have a time limit, whereas patents is 20 years. Copyright is usually life of the author plus 50 years. Then geographical indications. It's also one of the favored tools of indigenous peoples. Then industrial designs, which has been used, but is not very desirable because it has a time limit. Then, of course, trade secrets. Okay, so at this point, with all the information you have received so far, let us take a short break so that you can digest what you have received. And I pass the video and the microphone on to Edna.
Thank you very much, G. That's like one subject or 3 units of law school on intellectual property rights, right in your doorstep. Now, we are now open for questions and clarifications. So there's actually one question from Indonesia, from Krizi. How do Krizi? Okay, you can text your question, Krizi, if you can. Or you can talk. So Chrissy raised her hand, and we can give you the microphone now for questions. Earl? Okay, Chrissy, you may ask your question now. Chrissy?
Chrissy, can you?
Hello, can you hear me?
Yes.
Yes.
Oh, wow. Okay. Hi, Jane, Chrissy in Indonesia. Hello? Hello?
Yes, we can hear
Hello.
you. Go ahead.
Okay. I have several questions. Is it okay?
Several? Yes. Several, like, okay.
Okay, so the first is on geographical indications, because several of them have been implemented here in Indonesia. But some are kind of imperfect because, like, for example, for rice that's on the cross border between Indonesia and Sarawak, Malaysia, so only the Indonesian side of the tribe is able to use it. But then there's a question about the same tribe that's on the Malaysian side. That's one question. And then is it the geographic indications? Because what I understand, it's about location, but can it be a specific tribe in a specific area, or can anybody in that area with the same soil and the same whatever also have access and have the same rights? So that's with regards to geographic indication. And then another question is with regards to copyright, because you said copyright doesn't have to be registered. But then somehow I see a very slim line between art and industrial design, because it's about aesthetics, right? So
Yes.
so I mean, what if a lawyer of a big time company said that's not art and it's industrial design, therefore you're not registered and therefore you have no right. That's just something that I can see. So those na lang first, because maybe others have other questions.
Okay, now, Jean, can you answer that now?
Yes. Thank you for the questions, Chrissy. They're very good questions, actually. You're right, exactly right. As regards geographical indications, it is related to the area and the specific properties of the area that produces the product. Therefore, maybe there was an oversight here. Well, the problem is it only protects those who apply, right? So it's the Indonesians who applied, therefore they are the ones protected. However, as you said, they share the same properties with those in Sarawak. Okay, so the solution here would be for Sarawak to be included in the protection provided by the geographical indication. They can either apply separately. However, since it's the same properties that we are trying to protect, then I think it's better if they just get included with the Indonesians. If it's the same tribe, maybe there are tribal mechanisms for them to cooperate. The examples in Europe, there are some types of products that are found in many different areas, and since they share the same properties, therefore all the producers from those different areas come together. Okay, so that's a solution, I think, because of course those in Sarawak also have the right to be protected by that geographical indication. Okay, the next is copyright and industrial design. It's true that there are overlaps. In fact, many of those who have applied for industrial design protection are also protected by copyright. No? But the only difference here, okay. Yes, the only difference here is that industrial designs are for products that are really meant to be economically exploited. That's why they're given a short period of protection, unlike copyright. Of course, under copyright, there are also economic rights involved, because you can, for example, publish a book or present a play and ask the public to pay, no? So there are also economic rights. However, those who decide to go to protect their creations through industrial design, in addition to copyright, are those with the intent to intensively, so to speak, economically exploit the product. Okay? So they are not mutually exclusive, in short.
Okay. Thank you, Jean, for those questions. I hope Chrissy is satisfied. This is an evolving discussion, and we have 3 webinars scheduled. So on the third webinar, we'll have practical tools and approaches how to actually address and respond to issues like that. I think for the first question of Chrissy, it's more related to, can geographical indicators actually cross national boundaries? Because there could be one tribe, one kind of climate and soil, but spanning 2 political boundaries. We will answer that question later on, because there are 2 questions also. So from Mayor, the question, Jean, is what is the normal time required for getting GI? What are the various steps involved?
I can talk, yes, thank you. I can talk personally about the Tinalak Cebu which is actually intended to be a geographical indication but was registered as a collective trademark. So how long did it take? That's the question. And what are the steps involved? Of course, first we have to prove, relationship between the product and the place or the practices of the people. Therefore, a lot of documentation has to be undertaken. So in the case of the Tinalak, it took them 5 years because they had to painstakingly document, everything, the rules involved in creating the weaving, in creating the cloth. But once they got it to the Intellectual Property Office here in the Philippines, it didn't take very long. That whole process within the IP office was around a year, 1 year. Because, of course, they have to investigate whether the claims in the documentation are true, whether there really is a distinctive characteristic to that geographical area that would justify protection through a GI. Okay? So I think the long part is in, getting community buy-in and agreement to actually protect it. Okay. The next is no laws.
Yeah. So the next question is how can we use of intellectual property rights if there is no laws in our country available? This is from Thailand. Are you familiar of
Yes.
intellectual property rights in Thailand? Actually, they chair the ASEAN group that discusses traditional cultural expression.
They are very active. In fact, at WIPO, they are very famous. They are a famous delegation because whenever the discussion is related to traditional cultural expressions, they have a delegation of about 10 to 15 people. And they're all from the Ministry of Culture. And as far as I know, from what they have presented at the meetings of WIPO, there are laws that exist on trademark, on copyright, because these are the most relevant for traditional cultural expressions. And they do have an intellectual property office. In fact, I spoke once in a university gathering in Thailand, and they were showcasing, all the patents issued by the Thai Patent Office. So maybe we can conduct. One good resource that I have found that in the WIPO website, WIPO.int, there is a section there that provides copies of the national laws of various countries relating to intellectual property. So maybe we can have a look at that website and check if we have laws. Because as far as I know, Thailand does have intellectual property laws. Maybe they are doing a poor job of disseminating, but I think they do.
Okay, thank you very much. I think that wraps up our 5-minute Q&A. And there was this sharing from Myanmar that lacquer from Bagan is actually protected by geographical indications. Thank you, Amy. So let's proceed to the next subtopic under its introduction to intellectual property rights. So, Jean.
Okay, thank you very much again, Edna. Okay, so now we go to identifying the issues within the intellectual property system in relation to traditional knowledge. Okay, so are traditional knowledge intellectual creations? That was one of the answers that WIPO had to grapple with because, of course, here we see in the Solomon Islands, they have very distinctive dances that are intrinsically tied to the identity of the people. And then we have copper work, which is created. It's a community craft, so to speak. And then we have, of course, some orchids, and this is in Bhutan, that has certain properties that are would be interesting to patent. Then of course, we have all of these textiles produced by indigenous peoples. Okay, that one with the lizard there is actually with, the example that I was presenting earlier about the Aboriginal artist versus the carpet maker. Okay, okay. So in 1997, WIPO had to grapple with this whole issue of traditional knowledge, because traditional knowledge holders were saying at the time that the intellectual property system does not adequately protect their rights and interests as as traditional knowledge holders. And so a series of fact-finding missions were conducted by WIPO from 1997 to 2000, and this resulted in the establishment of the Intergovernmental Committee on Intellectual Property, Traditional Knowledge, Genetic Resources, and traditional cultural expressions. Okay, so let's look at the issues that were raised. So if you are counting, it has been 18 years since the establishment of the IGC, that is the short name of that committee. And we are hoping, those who have been involved in the process, that it will be concluded in the next 2 years. We're hoping, very, praying. So now, what are the issues that were identified by the TK holders? Well, of course, I had to insert the Philippines here. We have dances, we have weaving, and we also have traditional hunting practices, traditional forest management practices, and also some animals within our territories that would be interesting for pharmaceutical companies to investigate and patent. Okay? So, exactly what is traditional knowledge? It is know-how, innovations, information, practices, etc. Okay? That are developed within a traditional context, no? And maintained, by a collective, maintained and developed, by a collective. Okay? So now, examples. What are examples of traditional knowledge? Well, how to know when it is planting season, no? How to know when it is okay to harvest fish from a river, those kinds of things. What plants to use when we have wounds or if we have certain sicknesses, no? Those are traditional knowledge. So in the strict sense, WIPO says that traditional knowledge, it's this is just the idea, no? There's no expression, there's no tangible expression. So therefore, it may not be protectable. So what is the physical expression of traditional knowledge? It is usually this, yeah? Traditional cultural expressions, or the forms in which the culture and knowledge are expressed. And they are usually elements of cultural heritage. So these are the songs, the dances, paintings, drawings, crafts, textiles, etc. Okay? Then we have genetic resources. The resource itself, which is usually a plant or maybe sometimes an animal, is not creation of the mind, no? Because it's just a thing that produces the product. However, intellectual creation comes in looking for ways to use that genetic material, okay? So when you use the genetic material, it becomes a resource, and therefore there is a intellectual property aspect, okay? So what is the difference now? What were the issues? Traditional knowledge and TCEs are generally created in a collective context, by a collective. Whereas traditional intellectual property tools are individual. Of course, there are some exceptions, such as the collective trademark, but in general, these are all individual creations. And as I said earlier, this is because it was created during the industrialization era, where the sense of individualism was very strong. It's maintained in a collective context. TK is maintained in a collective context, whereas for intellectual property, it's usually the individual. It's also owned collectively, the TK, but the usual mainstream intellectual creations are again individual. Of course, for indigenous peoples, as long as they exist, then they own their traditional knowledge, no? Because it's intimately tied to their culture. For intellectual property, it's generally a fixed period of protection. And as for public domain, of course, because traditional knowledge for indigenous peoples is protected indefinitely, then it should never go into the public domain. But for intellectual property, I showed you earlier the arrow that illustrated the balancing of interests. Intellectual property puts a time limit to ownership so that others, the public, may benefit, no? After a person or after the inventor has amassed enough benefits from their invention. Okay? So, those are the issues that were raised and that the IGC seeks to address. So now, protection actually might mean many different things. Yeah? In fact, there are many instruments at the international level that seek protection of traditional knowledge and traditional cultural expressions. So, UNESCO is one forum, and here in UNESCO, the strategy is to document everything and to designate things as important, no? Important tangible cultural heritage and intangible cultural heritage. And that is their strategy in order to ensure that it is maintained, no? The knowledge is maintained. And on the other hand, there is the intellectual property system, as I said, creates fences around certain types of properties. So you see in the illustration there, one of the, absurd extensions of the logic of patenting, because we might end up with everything in our forests patented, no? But anyway, it's 20 years only. So there. So those are different types of protection. And in fact, other instruments provide other types of protection. Okay? So the human rights system also provides for protection. We have the UN Declaration on the Rights of Indigenous Peoples that says that indigenous peoples have the right to their creations, their intellectual creations. Okay? So, now we look at what protection means under the intellectual property system. If we register our creations under the system, this IP system, we are treating our TK and TCEs as intellectual property. Okay? So when we treat them as intellectual property, that means that we have a say over who can use, who can access and use our knowledge. Okay? And we can use intellectual property principles to prevent others from misusing our knowledge. Okay? So that's the exclusive rights model. And here in the Philippines, we have what we call free, prior, and informed consent. In our laws, before others can conduct bioprospecting in our territories, there has to be consent from indigenous peoples. So that's the exclusive rights. Then we have moral rights, no? Moral rights, which would mean we acknowledge the source, no? We acknowledge who is the rightful creator, and we prevent distortion. That's the technical term, or derogatory use. So an example. In my tribe, we have a skirt that is a wraparound skirt, and it's supposed to fall up to the knee. It's supposed to be knee length or slightly longer than knee length. However, in some dance troupes, folk dance troupes, they make these skirts into mini skirts or even micro mini skirts. Okay, so that's one example of derogatory use. And if you have moral rights, you have the right to prevent other people from using your knowledge in a way that that is not appropriate, no? That is distortion or mutilation of the way that it is supposed to be used. Then finally, this concept of access and benefit sharing. No? You use my knowledge, you have to compensate. Okay? And this is the model used by those tribes that have entered into partnerships with universities and other research institutions. Okay? So it's not perfect because of the public domain and the limited term, and also the exceptions and limitations, but it can be used to provide these three types of rights. Okay? What is an example? And of course, I present an example that is close to home here in the Philippines. There is a joint administrative order between the National Commission on Indigenous Peoples here in the Philippines and the Intellectual Property Office of the Philippines. Okay? And what they want to do is to address registration of certain intellectual property tools that use traditional knowledge in the development of their products or their creations. Okay? So, the scope is the examination of the registration of intellectual property applications. Okay? And their objective is to create, for both agencies to cooperate, no, in preventing the misappropriation of traditional knowledge. Here in the Philippines, we call it IKSP, Indigenous Knowledge Systems and Practices. Okay. So here in this order, it's no longer a draft. I'm sorry, I forgot to remove the draft from there, but it's already been enacted. All those who apply for intellectual property rights are required, it's mandatory disclosure, required to disclose whether or not they use traditional knowledge. Okay? In cases like copyright, where the registration is not required, the copyright owner needs to disclose in all communications on the subject matter that they have used the traditional knowledge of the specific tribe. Okay, there. So for patents, there has to be evidence of consent when patent applicants disclose that they have used traditional knowledge. They have to provide evidence of consent, free, prior, and informed consent, and benefit sharing. Okay, so this is one way that the Philippines has modified its intellectual property system to take into consideration traditional knowledge. Okay, so it's a sort of a wide-ranging power because the Intellectual Property Office can by itself, if it feels or if they have a suspicion that the application contains traditional knowledge, they can refer it on their own to the National Commission on Indigenous Peoples to check if there is compliance with consent. Okay, there. So that is one example of modifications to the intellectual property system to protect traditional knowledge. So, okay.
So,
let's take a break.
thank you again, Jean. Now we are now entering into the realm of the traditional knowledge and how is it protected? So how is it protected under the current mainstream WIPO system? So I don't see any questions, but I would like to throw in some questions, Jean. So you are very much engaged in the IGC and the WIPO. So at the national level, at the local level, we know that there is that recognition that every time there's use of traditional knowledge, there is a corresponding benefit. So what is the discussion, current discussion at the WIPO level? Do they subscribe to the belief that indigenous peoples and local community has the right to just compensation for the use of their traditional knowledge?
Yes. Yes, definitely. As I said, negotiations are ongoing. We are hoping still that it gets concluded in the next 2 years. But the current drafts of the negotiating instruments recognize that indigenous peoples and local communities need to be compensated for use of their traditional knowledge. In fact, in certain, certain parts of the text, when dealing with misappropriation or knowledge that was taken without consent, they want to limit, the consequences or the sanctions to merely providing compensation and back compensation, compensation for the time that they used the knowledge without consent and without having provided in the past compensation. Of course, the issues remaining are, some countries actually assert that the state or the entire nation, the entire country, owns all of the cultural heritage produced by all citizens within their borders. So that's one of the sticking points. So there is some controversy as to who receives the benefits. Would it be the country, in cases where the country owns all knowledge produced within its territory, or would it be the specific communities? Okay, so yeah,
Okay,
so it's there.
So related to that answer is actually a question from Krishna,
Yes.
a ninja, whom to share benefits
Yes.
with when TK is accessed, as the community might be geographically spread,
Ah,
even spread over
yes.
2 countries.
yes. The answer usually there is who the one accessing the knowledge negotiates with. So it's an imperfect system, as we said, because there is no requirement for all of those sharing the same knowledge to come together and collectively negotiate. So that leaves communities vulnerable, to being subject to, divide and conquer. Yeah. So that's a limitation. It's definitely a limitation of the system. But I think, yeah, it's also a limitation, I think, in the convention, in the Nagoya Protocol, because it leaves cooperation in cases like this to those from the community. It does not compel the person who is accessing the knowledge to involve everyone. No? So it's up to the communities to cooperate.
So you said that you are hoping that within 2 years we can have a protocol that actually addresses intellectual property rights of
Yes.
on TK associated.
Yes.
So usually laws are generally prospective.
Yes.
It would not apply
Yes.
before it was actually enacted. So are there any discussions how those rights,
Yes.
property rights, intellectual property rights already in the public realm
Yes.
and being abused or used
Yes.
would be protected under this WIPO system
Yes.
and TK system?
Yes. Very good question. In fact, we grappled with that at the last IGC session that I attended. Of course, the Group B of countries, which are the US, Australia, Canada, New Zealand, including Korea and Japan, because they are the top countries when it comes to intellectual property applications, they want the instrument to be only prospective because it contains a penal clause, yeah, penalties. However, we introduced during that session a concept of progressive repatriation, no? Because even those who have already obtained intellectual property rights would know whether traditional knowledge was involved. So there are 2 approaches, as I said. One is repatriation, which means that slowly the intellectual property rights holders would acknowledge the rightful owner of the traditional knowledge. And the second approach is the compensation approach, which, as I said, was preferred by everyone. So if there are instances when they have used knowledge without consent, then there would be compensation provided, no? And some penalties for the unauthorized use, the period where they use it in an unauthorized way. So, but as I said, this is still negotiation. Okay, so it's not final yet.
Okay, thank you. I have two more questions from our attendees. Krishna again, was a follow-up question. Traditional knowledge system versus the IPR system brings the collective nature of TK into the public domain. Yes, we learned that.
Yes.
And how to retain the collective nature of TK and still provide protection. Are this being discussed, or would you know of discussions as well as issues towards this?
Yes. Well, when it comes to patents, because of the requirement for an inventive step, it's the underlying traditional knowledge will not get patented. No, it's inventions based on the underlying traditional knowledge. Okay, which means that it will not be affected. Our TK, it's only that product that was derived from our genetic resource and our traditional knowledge. So that ownership over the underlying TK and GR would still remain with the collective. Okay, that's one of the approaches. And also in the IGC, the current drafts all recognize that none of the instruments should restrict the traditional or customary uses of the resources and the knowledge of indigenous peoples. So that's as far as the mainstream system is concerned. The other approach that we could take is through community protocols. And we will go into detail about community protocols at our third webinar, because this is a way for us, it's so a sort of tailor-fit way for us to bring our concerns, no? To impose the rules of the community on others who want to use the things owned by the community.
Okay. Thank you. The next question is actually about this TV show, Bagani in the Philippines, from an anonymous attendee. It said, is there basis for the public uproar over the TV show Bagani in the Philippines?
Yes, there is. Indeed, there is. At first, I thought that the Bagani was sufficiently generic, that anyone could use it. However, I was corrected by the Manobo tribes. Yeah, there are many different Manobo tribes in Mindanao, and they said that it's distinctively associated with the Manobo. And this, the cudgels for the Manobo were taken up by a congresswoman who is also Manobo, and one of the commissioners of the Commission on Higher Education here in the Philippines, who is also Manobo. Okay, and so they had a dialogue with the TV show, the producers of the TV show, and the compromise was there was a disclaimer at the start of the series. Every time it shows, there's a disclaimer saying that Bagani actually exists, and they are associated with the Manobo, with the indigenous peoples of the Philippines. Okay, no compensation, unfortunately. It was just moral rights that were addressed. But of course, there was basis for the uproar.
Okay, thank you. Now we can move to the last part of our webinar, which is this a few slides more, and then we go to another, like the Q&A proper, that we can have some discussion. Okay, Kate?
Okay, thank you very much. Now, the last part is a special request, actually, because since we are very much involved with our communities in protection of indigenous products through the trademark system, I wanted to present, well, I was requested to present this Madrid system. Okay, so again, the Madrid system is a system administered by the World Intellectual Property Organization, and it is essentially meant to simplify trademark protection in many different countries. So, for example, you remember the trademarks that we had earlier. My 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 community has obtained a trademark, for example, and you want to export it to other countries, or you want it to be protected also in other countries. For example, here in the Philippines, I understand English very well. We have lawyers here. However, if I want to protect it in Vietnam, for example, I would need to hire a local lawyer, intellectual property lawyer. I would need to hire interpreters, as well as the administrative costs, such as my airfare going there to seek protection. This Madrid system makes that process. Okay, excuse me. Okay, the first agreement was in 1891. Then a protocol. Okay, that's 1981. Sorry, mixed up the numbers. And then a protocol was agreed in 1989, and these protocols make up the Madrid system. They are administered by the WIPO, the International Bureau of WIPO, and they maintain the International Registry of Trademarks, and they also publish registered trademarks in the Gazette of International Marks. Okay, again, also maintained by WIPO. There are 116 out of the 191 WIPO members. Only 116 so far are members of the Madrid Union, which means that they ratified the Madrid agreements. And as far as Asia is concerned, these are the countries that are members. Okay. The European Union is a member also. So many countries covered. So the objectives of the system is to facilitate the protection for marks. Okay. Once a mark is registered, in the international registry, it's equivalent to a bundle of national registrations, which means that it's considered registered in the different countries that you want it to be, your trademark to be protected. Okay, and it's also easy to renew, to amend, and to provide limitations to your trademark. Okay. So, second to the last slide, how does it work? First, you have to have your application at the national level, okay? At your local trademark office or intellectual property office must have approved the registration of your trademark, okay? The national office is called this Office of Origin, okay? Now, if you want it to be registered in many different countries through the Madrid system, your Office of Origin has to forward the application to WIPO. Okay? The applicant cannot go directly to WIPO. It always has to pass through the Office of Origin. Okay? Then WIPO formally examines, and if it passes the criteria for registration, then it registers the mark in the international registry and publishes this in the Gazette. But let's backtrack a step first. In the form that you have to fill out with your Office of Origin, you have to tick certain boxes there of the countries where you want your trademark to be protected. Okay? There is a single fee system, so it's not like before where many different fees need to be paid. Here, for each country, they will be declaring a single fee to be used for the Madrid system. So it's more simplified. But for every country you check, you have to pay something. And for every class of goods that you designate, you have to pay also additional. Okay? But once it goes to WIPO and once WIPO registers it, it's already considered, before it registers, WIPO has to forward the application to the different countries that you have checked in your application. Okay? And they have to assess whether your trademark is protectable under their national laws. Okay? This is one of the features of the international system. They also want, they always want to be respecting the national frameworks. Okay? So once WIPO has examined it, they still have to forward it to the various countries. But at least the innovation here is that the applicant himself or herself does not have to go to the various countries in order to shop the, to apply for registration of the trademark. Okay. So once the countries have accepted the registration, then WIPO can publish the mark in the international registry, and it issues a certificate of registration. Okay, so that's it. It's basically an international system meant to provide simple procedures and rules for protection of marks in various countries that are members of the Madrid Union. Okay, so that's the Madrid system. And finally, we conclude our webinar, the first in our series. We have seen that although there are gaps within the intellectual property system, it is possible to provide limited types of protection for traditional knowledge and TCEs using the tools that are currently available. Okay. However, the gaps, of course, they need to be filled. And we identify certain approaches that we can take to fill the gaps at the next webinar. So we look more deeply into case studies on how tribes or indigenous peoples have used intellectual property tools to protect their TK. And we also look more deeply into approaches that we can take at the national level, to expand protection of TK by expanding our protection system or creating our own tailor-fit sui generis systems. So that's all for this presentation, and I thank you very much for your attention. So now I guess we open for questions, huh?
Yes.
Okay, so thank you.
Thank you very much, Jing. That was a very comprehensive introduction to mainstream intellectual property rights. As you said, in the next webinar, we will go into really deep dive into traditional knowledge and traditional cultural expression and look at case studies.
Mm-hmm.
This is actually the part I am looking forward to, as
Yes.
well as the third installment of our webinar, because the third webinar, we're exploring out-of-the-box
Yes.
tools and approaches, because we cannot wait for the 17 years and counting protocol under WIPO, and this can be also costly, right? So the third webinar, we look at what are our potential pathways towards protection of TK without going into the expensive and formal WIPO system. Okay, so there are no questions in my Q&A box, so that's good. I don't have any further question, but just for logistics purposes, no? So we will have the next webinar, which you will have to register. This will be on May 3 at the same time. We will be sending out the presentation as well as additional reading list if you are interested of this first webinar in the next coming days. This is also recorded, and we can share it in the coming days also. If you are also interested in some additional reading list, we can also share with you cases of actual cases that has been decided from different countries of cases between indigenous people and on traditional exercising their rights to IPR of their associated traditional knowledge. With that, I thank you all for participating with us. Thank you very much, and thank you also to our team Dazzle and Earl for backstopping us in this webinar. Thank you very much, G, and we look forward to the next discussion on May 3. Oh, there's a chat. Okay. Messages in chat? Is this? I think. Thank you very much. Now signing off.